Here's the world's best cheat sheet for quick and powerful exam revision on the Industrial Disputes Act, 1947, arrangement of sections up to Section 10A, short, precise, and complete. Industrial Dispute Act, 1947, crisp cheat sheet, purpose. To maintain industrial peace and harmony by providing machinery for investigation and settlement of industrial disputes between employers and workers. Chapter 1, Preliminary. 1. Short title, extent, and commencement. Title, Industrial Disputes Act, 1947. Extent, Whole of India. Commencement, came into force on the 1st April 1947. Memory anchor, SEC, short, extent, commencement. 2 definitions. Defines key terms. Industry. Systematic activity between employer and workman for producing, distributing goods, services. Workman. Any person employed, manual, skilled, unskilled, clerical, technical, except managerial or supervisory staff. Employer. Person employing workmen directly or through an agent. Industrial dispute. Any disagreement between employer and employees about employment, non-employment, or working conditions. Memory tip. ID equals industry plus disagreement. 2A. Dismissal of an individual workman. Even if one worker is dismissed, it is treated as an industrial dispute. No need for group support. Example. If one worker is unfairly fired, he can raise a dispute directly. Anchor. One man's dismissal, industrial dispute. Chapter 2. Authorities under the Act. Authorities created to prevent and settle disputes. 3. Works Committee, made in industrial establishments with 100+ workers, members from employers and employees. Function, promote harmony and smooth communication. Trick, 100 workers, Works Committee starts working. 4. Conciliation officers, appointed by the government, central or state. Duty, mediate and promote settlement between parties in dispute. Trick, conciliate equals cool down conflicts. 5. Board of Conciliation, a temporary board, chairmen equal employer and employee reps. Purpose, try to bring both parties to an agreement. If failed, sends report to government. 6. Courts of Inquiry, investigate matters connected with an industrial dispute. Aim, find facts, not to give judgment. Example, court finds causes of frequent strikes in a factory. Anchor, inquiry equals investigate facts. 7. Labor courts, judge-type bodies to decide industrial disputes on certain subjects, like dismissals, wages, strikes, constituted by state government. Anchor, labor court equals first judicial stage. Tribunals handle complex and important industrial disputes, like wages, hours, bonus, appointed by central or state government. Trick, tribunal, tough disputes. 7B. National tribunals, for national-level disputes affecting 2 or more states, appointed by central government only. Example, dispute between Indian Railways and workers in multiple states. Anchor, national tribunal equals multi-state trouble. 7C. Disqualifications of presiding officers. Person cannot be a presiding officer if convicted of an offense involving moral turpitude, bad conduct, found insolvent, has financial interest in the dispute, is biased. Trick, pure and impartial person only. 7D. Qualifications, terms, and conditions. Presiding officer must be judge or experienced person in labor law. Conditions of service decided by government. 8. Filling of vacancies. If a post becomes vacant, government fills it without delay to ensure no work stops. Anchor, no gap, no delay. 9. Finality of orders. Once a board, court, or tribunal is formed, its constitution cannot be challenged in court for minor reasons. Prevents delays by legal objections. Anchor, final formation equals no further fuss. Chapter 2A, Notice of Change. 9A, Notice of Change. Employers must give 21 days notice before changing service conditions, like wages, hours, leave. Prevents sudden shocks to workers. Trick, 21 days warning before work change. 9B, Government power to exempt. Government can exempt any establishment from giving notice if it feels necessary, e.g., emergency. CAC Chapter 2B, Grievance Settlement Authorities. 9C, Grievance Settlement Authority, GSA. For individual worker disputes, employer must set up GSA in establishments with 50+ workers. Dispute first goes to GSA before labor court. Anchor, 50 workers, GSA gate opens. Chapter 3, Reference of Disputes 10. Reference to boards, courts, or tribunals. Government may refer dispute for settlement to Board of Conciliation, Court of Inquiry, Labor Court, Tribunal, National Tribunal. Reference equals official sending of dispute for judgment. Trick, Gov sends dispute to experts for fair play. 10A. Voluntary arbitration. Employer and workers may mutually agree to appoint a neutral arbitrator before dispute goes to court. Settlement by mutual consent, not compulsion. Anchor agree, arbitrate, avoid court. Quick memory formula. SDAAA-RA. Short title. Definitions. Authorities. Appointment and arbitration. Reference of disputes. Agreement. Voluntary arbitration. Daily revision tricks. 1. 5-minute review rule. Read this cheat sheet aloud every morning. Focus on keywords, e.g. conciliation, tribunal, notice, arbitration. 2. Finger method. Assign each authority to one finger. Recall sequence from Works Committee National Tribunal. 3. Story link. Imagine a factory dispute story. Workers complain, Works Committee tries, conciliation officer helps, board tribunal judges, National Tribunal solves, arbitration equals peace. 4. Weekly challenge. Every Sunday, write all 10 key sections from memory. Check order and keywords. 5. Exam tip. Remember section ranges. 1 to 2A. Basics. 3 to 9. Authorities. 9A, 9C. Notices and grievance. Dispute references. Would you like me to make a visual memory map, color-coded diagram of this cheat sheet next to help you remember each chapter and section faster, like a story? The Industrial Disputes Act, 1947, crisp one-page cheat sheet, best for last-minute exam revision, all key points, dates, and memory anchors in one place. Basic details. Full name, the Industrial Disputes Act, 1947, Act No. 14 of 1947. Date passed, 11th of March, 1947. Came into force, 1st April, 1947. Purpose, to investigate and settle industrial disputes and maintain industrial peace. Type, labor welfare legislation. Main objectives, prevent and settle conflicts between employers and workers, ensure industrial peace and productivity, provide legal framework for negotiation, mediation, and adjudication, protect rights of workers and employers equally. Chapter 1, Preliminary. Section 1, Short Title, Extent and Commencement. 1. Short Title, Industrial Disputes Act, 1947. 2. Extends to whole of India, amended 1956. 3. Enforced from 1st April 1947. Memory trick. SEC equals short title, extent, commencement, always Section 1 of Acts. Section 2, key definitions. Most important for exams. A. Appropriate government means the authority that handles a particular industrial dispute. Central government handles disputes relating to central controlled industries like railways, banking, insurance, air transport, oil and natural gas, LI, ONGC, FCI, AAI, RRBs, etc. Corporations owned, controlled by central govt, 51% share capital. Central public sector undertakings, PSUs, and their subsidiaries. State government handles disputes relating to state-controlled industries, state PSUs, and state autonomous bodies. Example, if workers of LIC strike, central govt. If workers of Maharashtra State Transport strike, state gov. Tip, central equals national level industries, state equals local industries. A. Arbitrator, a person chosen to settle disputes outside court. Includes an umpire who decides when arbitrators disagree. Memory hook, A for arbitrator equals A for alternative to court. Average pay. Refers to the average wages earned by a worker in a given time period before payment becomes due. For monthly paid workers, average of 3 complete months. For weekly paid workers, average of 4 complete weeks. For daily paid workers, average of 12 full working days. If worker hasn't worked full period, calculate on the basis of actual period worked. Example, a monthly worker earned 15,000, 15,500, 16,000 in last 3 months. Average pay, 15,000 plus 15,000, 15,500 plus 16,3 equal to 15,500 memory trick. 3 to 4, 12 rule. Monthly, 3. Weekly, 4. Daily, 12. Important amendments for bonus marks. 1956, extended to whole India. 1964 to 1996, added new industries like LIC, ONGC, FCI, AAI, RRBs, NHB, etc. 1971, deleted old clause, now applies to both central and state sectors. Purpose in simple words. The Act ensures that if any fight or problem dispute happens between workers and employers, there are clear legal ways, like conciliation, arbitration, tribunal, to solve it peacefully. Why this act is important: reduces strikes and lockouts, promotes industrial peace, both sides, supports economic stability by keeping industries running smoothly, and daily revision tricks. 5-minute daily flash recall. Say aloud, 1947 Act, Peace in Industry, Investigation and Settlement. SEC 1, Short Extent Commencement. S2, Definitions, Appropriate Govt, Arbitrator, Average Pay 3 to 4 to 12. Visual trick. Imagine a factory where Central Gov handles national factories, like ONGC, LIC. State Gov handles local factories, like State Transport. Sticky note mnemonic. CSA equals Central State Arbitrator. Covers main definitions. Quick quiz tip. Exam will ask, who is appropriate Govt or define average pay? Always quote the rule. 3 months, 4 weeks, 12 days. Rapid revision rule. Every day for 5 mins. Recall year 1947. Purpose, investigation, settlement. Section 1, SEC. Section 2A, meanings. Hash keywords for exam, industrial peace. Investigation, settlement, dispute, appropriate government. Arbitrator to 412 rule. First 1947, number 4/1947. Would you like me to now make a visual mind map version of this, color-coded for memory? It'll help you recall the entire act in one glance before exam. Industrial Dispute 1947, cheat sheet, key terms and meanings. No fluff, all key points, smart memory tricks. 1. Award, meaning, decision judgment given by Labor Court, Industrial Tribunal, National Industrial Tribunal, covers any industrial dispute or question related to it. Types, interim award, temporary decision till final one. Final award, complete decision ending the dispute. Includes arbitration award under Section 10A if parties voluntarily go for arbitration. Tip, award equals court's decision in labor dispute, interim, final, arbitration. 2. Banking Company, BB, defined under Section 5 Banking Companies Act 1949. Condition, must have branches in more than one state. Includes Export-Import Bank of India, EXIM, Industrial Reconstruction Bank of India, IRBI, Small Industries Development Bank of India, SIBI, Reserve Bank of India, RBI, State Bank of India, SBI, corresponding new banks, 1970 and 1980 Acts, subsidiary banks, SBI Subsidiary Banks Act, 1959. Trick, big RBI family equals EXIM plus IRBI, RBI plus SBI's new banks subsidiaries. Trick, Board C, means Board of Conciliation constituted under this act. Purpose, to bring peace, tries to settle disputes through discussion, not judgment. Trick, board equals bridge between workers and management. 4. Closure, CC, meaning permanent shutdown of workplace or a part of it. Keyword, permanent closing down. Fact that's permanently due to losses. Trick, closure equals closed forever. 5. Conciliation officer, D, officer appointed under the act. Duty, mediate, persuade, and help both parties reach an amicable settlement. Trick, conciliation, convincing both sides to agree. 6. Conciliation proceeding, E, meaning any meeting or process held by a conciliation officer or board to settle dispute. Trick, conciliation proceeding equals peace meeting. 7. Controlled industry, E, meaning any industry whose control is taken by union, central government under a law because it's in public interest. Example, defense, railways, or atomic energy industries. Trick, controlled equals central government control. 8. Court F, means court of inquiry constituted under this act. Purpose, to investigate, not decide the causes of disputes and report findings. Trick, court of inquiry equals finds facts, not judgments. 9. Employer, G, 2 types. 1. If industry is run by central or state govt, head of department or prescribed authority. 2. If industry is run by local authority, e.g. municipality, chief executive officer, CEO of that authority. Trick, gov's head, local equals CEO. 10. Executive, GG, in trade union context, body managing its affairs. Whatever name it's called, committee, council, etc., it's the leadership group. Trick, executive equals union's boss team. Mar 11. Independent person, H. A person is independent if not connected with the dispute or the industries involved. Can still be independent even if he owns some shares in a company affected by dispute. But he must disclose this to the appropriate government, central state. Trick, independent equals no bias. If shares, must share info. Additional smart notes. Section 10A, voluntary arbitration provision, award included. Industrial Tribunal, higher level court for complex disputes. Labor Court handles simpler individual disputes, like dismissal cases. National Industrial Tribunal for cases involving multiple states or national interest. Conciliation, settlement without fight, adjudication, court judgment. Quick memory anchors. 1. ABC trick. Award equals judgment, Board equals bridge, conciliation. Closure equals closed forever. 2. C4 trick, conciliation officer conducts conciliation proceeding, creates compromise. 3. E3 trick, executive equals union's head, employer's organization's head, independent equals neutral head. 4. Bank Big 7, RBI plus SBI, Exim, IRBI plus EBI, new banks, 1970-1980 plus subsidiary banks. Daily revision tricks. Day 1, revise definitions aloud, award to independent, 10 mins. Day 2, write keywords only, test recall, 5 mins. Day 3, quiz yourself with flashcards, who gives award, etc., 10 mins. Day 4, teach it aloud to imaginary student, best memory lock. Day 5, quick final revision using ABC plus C4 plus E3, formula, 5 mins. Super memory tip. Imagine a factory movie. Judge, award, giving final decision. Bank family, RBI, SBI, funding it. Board sitting for peace talks. Officer calming both sides. CEO running local plant. Neutral man watching fair play. Visualize it. Your brain locks every word. Would you like me to make a visual memory map, comic style or diagram, of these definitions for daily revision, color-coded, like a brain map? It'll help you remember all terms in 5 mins daily. Industrial Disputes Act, 1947, definitions, cheat sheet, super crisp one-page revision notes with memory anchors, daily tricks. Part 1, industry, secte, meaning any business, trade, manufacture, or calling of employers, includes services, employment, handicrafts, or industrial occupation of workmen. Keyword trick, every place where workmen plus employers equals production service equals industry. Example, factory, bank, transport, or hospital, if employees do systematic work for wages. 2. Industrial dispute, meaning dispute or difference between employer, employer, workman, workman, reason of dispute, related to employment or non-employment, hiring or firing, terms of employment, wages, hours, etc., or conditions of labor, safety, leave, facilities. Memory anchor, 3 E's, employment, non-employment, employment terms. Example, workers demanding higher wages or reinstatement after dismissal. 3. Industrial establishment or undertaking, Sec 2 KA, meaning any place where any industry is carried on. If multiple activities exist, A, if industrial unit is severable, separate, it is independent industry. Example, a textile mill, separate canteen, both can be treated separately if canteen runs independently. B, if non-industrial activity helps main industrial one, whole unit equals industry. Example, head office supporting factory, both together equals industry. Trick, main plus helper equals 1, separate equals alone. 4. Insurance company, meaning as per Insurance Act 1938 with branches in more than one state. Example, LIC, ICI Lombard, SBI Life. Anchor, multi-state insurance equals industrial insurance company. FIDI, meaning as defined in Khadi and Village Industries Commission Act 1956, it means cloth made by hand-spun yarn, usually from cotton, silk, or wool. Example, Khadi clothes sold by KVI stores. Anchor, Khadi equal hand, village, simplicity. Number 6, Labor Court, Sec 2B, meaning court formed under Section 7 of the Act, handles individual disputes, e.g. dismissal, leave, wage issues. Trick, Labor Court equals judge for workers' fights. Layoff, Sec 2 Act, meaning when employer fails, refuses, cannot give work to a workman because of shortage of coal, power, raw material, accumulation of stock, machinery breakdown, natural calamity, or other connected reason. Conditions, worker's name on muster roll, official list. He has not been retrenched, permanently removed. Explanation, if worker reports on time but not given work within 2 hours, laid off for that day. If told to come in second half of shift and gets work, laid off for half day. If no work even in second half, entitled to full basic wage plus DA for that half. Anchor, layoff equals temporary no work, retrenchment equals permanent no job. Example, power cut in factory, workers come but can't work, laid off for the day. Memory anchors, quick recall tips. Industry, works employer employee equals output. Dispute any fight about job or conditions. Establishment, place of industry. Layoff equals temporary rest, no work due to reason. Retrenchment, permanent cut, no job anymore. Daily revision tricks. 5-minute flash rule. Every morning, revise one example. Keyword chain. Industry, dispute, establishment. Visual memory. Imagine industry equals factory gear. Dispute equals tug of war. Establishment equals building. Layoff equals worker sitting idle. Mini test. Daily. Write one definition from memory and check accuracy. Weekly drill. Explain all 7 terms in your own words. Keep answers under 30 seconds each. Golden exam tip. If the question asks define plus explain with example, start with definition from act, then explain meaning. Add one example. Finish with importance in labor law. Would you like me to make the next one-page cheat sheet on retrenchment, strike, lockout, closure, and unfair labor practices? The next important definitions from the same act? World's Best Cheat Sheet. Industrial Disputes Act 1947, Section 3, Works Committee, plus State Amendments. Section 3, Works Committee. Purpose: to promote peaceful relations between employers and workers in large industrial establishments. Applicability: applies to industrial establishments with 100 or more workmen. Includes any establishment where such number was employed on any day in the past 12 months. Authority: the appropriate government, state or central, depending on industry type, can order the employer to form the committee. Members represent both employers and workmen. Addition: number of workmen's representatives, the employer ensure fair balance. Selection: workmen's representatives are chosen in prescribed manner, in consultation with their trade union, if any, registered under the Indian Trade Unions Act, 1926, Act 16 of 1926. Main duty of Works Committee, Section 3(2). 1. Promote amity, good relations between employer and workers. 2. Preserve peace in the workplace. 3. Discuss and comment on common interest matters like canteen safety, leave rules. 4. Settle minor differences through discussion before they become disputes. Example: a factory with 200 workers forms a works committee. Workers complain about canteen hygiene. The committee discusses with management. Both agree on a cleaning schedule. Dispute avoided. State amendments. Manipur Amendment, Disturbed Areas Special Courts Act, 1976. Note: this part refers to another act, but was amended under Manipur's context. Insertions and changes. Context: to deal with armed violence by unlawful associations, declared under Unlawful Activities Prevention Act, 1967. Changes made: added reference to extension and indiscriminate armed violence by such groups. Modified proviso clauses to restrict period specification regarding violence-related cases. Added new clause, AA. When armed violence occurs, the specified period cannot begin earlier than A. The date of publication of notification under AFSPA 1958, or B. 2 years before the date of notification under this Act, whichever later. Inserted via Manipur Act 11 of 1982, Section 2. Rajasthan Amendment. Insertion of new Section 3A, Registrar and Assistant Registrar of Unions. Purpose: to supervise union activities and ensure proper registration within the state. Details: 1. Registrar of Unions, appointed by state government by notification in Official Gazette, covers entire state. 2. Assistant Registrar, appointed similarly for local areas, can be given all or some powers of the registrar by government order. Added via Rajasthan Act 34 of 1958, Section 4. Insertion of new Chapter 2B after Section 9B. Announced but full text not included in extract, indicates further administrative structure in future sections. Quick memory anchors, tricks. 100 peace talk. Trick 100, establishment with 100 workers. Representatives, equal or more from workmen. Peace, main goal harmony. Talk, discussion before dispute. Rajasthan registers, Manipur manages violence. Rajasthan equals Registrar of Unions. Manipur equals Management of Armed Violence, Disturbed Areas Act. Exam tips: always write appropriate government, not just government. Quote the 100-worker condition. Mention consultation with Trade Union, 1926 Act. Highlight amity and good relations, key phrase. State amendments show federal flexibility. Mention Rajasthan and Manipur differences. Daily revision tricks. Day 1, read Section 3, memorize the 100-worker condition. Day 2, recall committee composition flashcards. 3. Revise Manipur and Rajasthan amendments. Use Rajasthan registers rhyme. Day 4. Practice writing short notes on Works Committee's purpose. Day 5. Quick quiz yourself with who appoints, how many workers, what duties. One-line essence. Open quote, the Works Committee is a bridge of peace between employer and employees, ensuring cooperation before conflict. Close quote. Would you like me to make a pictorial mind map version? Like a colorful memory chart with boxes and arrows for this section. Perfect for last-minute visual revision? Ultra Best One-Page Cheat Sheet, Chapter 2B, Registration of Unions, Industrial Disputes Act, Rajasthan Amendment, crisp bullets, no point missed, exam-perfect keywords, quick revision anchors. 9C, Maintenance of Register, Duty of Registrar, keep official register of all registered unions. Form as prescribed by rules. Memory anchor, registrar equals record keeper. 9D, Application for registration. Who can apply? A union having at least 15% membership of total workers in a unit of an industry. Condition, must hold that 15% membership continuously for 3 months before applying. Form, application in prescribed format to registrar. Trick, 15% plus 3 months entry ticket for registration. 9E, Registration of Union. Registrar checks, 15% condition, fee paid, no disqualification. If satisfied, enters name in register under 9C, plus gives certificate of registration. If multiple unions apply, the union with largest membership gets registration. Registrar must refuse registration if union formed not bona fide, fake created by employers to weaken real unions. Anchor largest genuine voice wins registration. 9F, Cancellation of registration. Registrar can cancel if A, after inquiry finds 1. Mistake, fraud, misrepresentation in registration. 2. Membership falls below 15% for 3 months. Exception, if legal strike closure 14 days, that month not counted in 3 months. Further proviso, cancel only if membership still below minimum at time of cancellation. 3. Union working for employer's interest, not workers. 4. Union instigated assisted illegal strike. B. If its registration under Indian Trade Unions Act 1926 is canceled. Trick, fraud, fall, fake loyalty, or illegal strike equals cancellation. #9G, registration of another union in place of existing union. 1. New union applicant claims larger membership than existing representative union. 2. Registrar sends notice to old union to reply within 1 month. 3. Copy of notice, Labor Commissioner. 4. After inquiry, if applicant has larger 3-month membership, register it in place of old one. Application published at least 14 days before notice expiry. Anchor, bigger crowd equals new representative. 9H, re-registration of canceled union 1. If canceled for mistake falling membership, 9FAE may reapply after 3 months plus pay fee. Same rules as 9D and 9E apply. 2. If canceled for other reasons, fraud, illegal strike, etc., can reapply only with state govt permission. Trick, small fault equals wait 3 months, big fault ask govt. 9I, appeal to industrial tribunal. 1. Who can appeal? Any party to registrar's proceedings. 2. Time limit. Within 30 days, tribunal may accept late appeal for valid reason. 3. Grounds. If order is illegal or erroneous. 4. Powers of tribunal. Confirm, modify, cancel registrar's order. Pass consequential orders. Copy sent to registrar. Anchor. Registrar's boss equals industrial tribunal. 9J, publication of orders. All orders under 9E, registration. 9F, cancellation. 9G, replacement. 9I, appeal. Must be published publicly in prescribed manner. Trick, every decision goes public. Transparency. Extra insight. Purpose, to ensure only genuine, majority representing, fair unions get legal recognition. State example. Rajasthan introduced this system via Act 34 of 1958. Prevents fake or unions from misleading workers. Daily revision tricks. 15-3 rule. 15% membership for 3 months eligible. 4C rule for cancellation. Cheat, collapse, membership, corrupt motive or conflict, illegal strike. 1M rule. 1 month notice for old union to reply when new one applies. 3M reapply rule. 3 months gap before re-registration, minor cases. Tribunal equals appeal authority, 30 days limit. Transparency, publish all orders. Memory anchors, 9C, create register. 9D, demand registration, 15% plus 3 months. 9E, earn registration. 9F, fail equals cancel. 9G, get replaced. 9H have re-registration. 9I industrial tribunal appeal. 9J just publish orders. Quick exam recap. Registrar equals record keeper and decision maker. Minimum strength 15% workers for 3 months. Genuine plus majority plus lawful registered union. Fake plus employer-backed low strength equals canceled union. Appeal lies to industrial tribunal within 30 days. Transparency. Every decision must be published. Would you like me to create an ultra-compact mnemonic map, a memory diagram or word chain that helps recall all 9C, 9J sections in under 30 seconds for last-minute exam revision? Industrial Disputes Act, 1947. Ultra Best one-page cheat sheet. Conciliation Officers, Board of Conciliation, Courts of Inquiry, Labor Courts. 1. Conciliation Officer, Sec. 4. Appointed by appropriate government, central state. Notification, in Official Gazette. Duty, mediate and promote settlement of industrial disputes between workers and employers. Appointment type, for a specific area or specific industries in an area. May be permanent or temporary. Example, Gov appoints a conciliation officer for textile mills in Mumbai for 6 months to resolve strikes. Memory trick, C for conciliation equals calm and compromise maker. Nash 2, Board of Conciliation, Sec. 5, constituted by appropriate government when needed. Purpose, promote settlement of industrial disputes, published in Official Gazette. Composition, chairman, independent person, 2 or 4 members, equal representatives of both parties, employers and workers. If party doesn't recommend representative, Gov appoints anyone it thinks fit. Quorum rule, board can act even if chairman or any member absent, but if Gov says chairman's service is not available, board can't act until new one appointed. Memory trick, B for board equals balanced body, equal reps. Court of Inquiry, 6. Constituted appropriate government when needed. Purpose, to inquire into any matter connected with or relevant to an industrial dispute. Notification, in Official Gazette. Composition, either one independent person or 2 or more independent persons, one as chairman. Quorum rule, can act even if someone absent, but not if chairman unavailable, until new one appointed. Example, Gov forms court to investigate causes of large-scale layoffs in steel industry. Memory trick, court equals check and clarify causes. 4. Labor courts, Sec. 7, constituted by appropriate government, central state. Purpose, to adjudicate, decide disputes related to matters in second schedule, e.g. dismissal, retrenchment, unfair labor practice. Perform other functions assigned under the Act. Published in Official Gazette. Composition, 1 person only, presiding officer. Qualification for presiding officer, must be one of the following. 1. High Court judge, current or former. OR 2. District, additional district judge for 3 years. OR 3. Judicial officer in India for 7 years. OR 4. Presiding officer of a state provincial labor court for 5 years. Or 5. Deputy Chief Labor Commissioner, Central or Joint Labor Commissioner, State, law degree, plus 7 years experience, 3 years as conciliation officer. Must resign from Gov service before appointment. 6. Indian Legal Service Officer, grade 3, with 3 years experience in that grade. Memory trick, judge plus justice, labor expert equals labor court head. Quick comparison table in words, not columns. Conciliation officer, single mediator, helps in settlement. Board of Conciliation, group of members, mediate between parties. Court of Inquiry, investigates, fact-finding body. Labor Court, judicial body, decides disputes legally. Important notes, all appointments are done by notification in the Official Gazette. All bodies work to prevent, investigate, or resolve. Conciliation equals peacemaker, court equals fact-finder, labor court equals judge. Memory anchors and daily revision tricks. 5-min daily drill, recall order, conciliation, board, court, labor court. Keyword hook, CBCL, calm, conciliation, balance, check, court, law, labor court. Visual trick, imagine a dispute fire. Conciliation officer brings water, cooling. Board of Conciliation brings more helpers. Court of Inquiry inspects how fire started. Labor court gives final judgment who's responsible. Weekend review, write 1 real example from news or your own example for each body. Golden tip, conciliation tries to settle, court tries to study, labor court tries to decide. Would you like me to make a super compact visual mind map version of this, like a color-coded 1-page picture for revision? It'll help memorize 5 times faster. Ultra-compact one-page cheat sheet. Labor Courts and Industrial Tribunals, Section 7 and 7A of Industrial Disputes Act, 1947. Labor Courts, Section 7. Set up by appropriate government, central or state, by notification in Official Gazette. Purpose: to adjudicate, decide industrial disputes about matters in the second schedule, e.g., misconduct, dismissal, wages, working conditions. Other functions: any extra duties assigned by government under the Act. Structure: consists of only one person, called presiding officer. Qualification of presiding officer: must be one of the following: judge of a high court, current or former. District or additional district judge with at least 3 years experience. Judicial officer in India for 7+ years. Presiding officer of a labor court under any state provincial act for 5+ years. Deputy Chief Labor Commissioner, Central or Joint Labor Commissioner, State. Must have law degree, 7+ years in labor depth, in cloth 3+ years as conciliation officer. Must resign from gov service before appointment. Officer of Indian Legal Service, grade 3, 3+ years experience in that grade. Industrial Tribunals, Section 7A. Set up by appropriate government, central state, by notification in Official Gazette. Purpose: to decide industrial disputes in second to third schedules, includes wages, bonus, retrenchment, closure, etc. Extra function after Finance Act 2017. Central Gov Tribunals also handle EPF, Employees Provident Fund disputes under Sec 7D of EPF Act 1952. Structure: consists of only one person, called presiding officer. Qualification of presiding officer: must be one of judge of a high court, current or former. District or additional district judge with 3+ years experience. Deputy Chief Labor Commissioner, Central or Joint Commissioner, State. With law degree, 7+ years in labor depth, in cloth 3 years as conciliation officer. Must resign before appointment. Officer of Indian Legal Service, grade 3, 3+ years experience in grade. Assessors: Gov may appoint up to 2 assessors to advise the tribunal, not decision makers. Key terms and memory anchors. Second schedule, simple disputes, wages, dismissal, misconduct. Third schedule, bigger issues, wages, bonus, retrenchment, closure, etc. Presiding officer, always one person. Notification in Official Gazette, formal government announcement. Appropriate government, central governed for industries under its control, railways, mines, etc. State governed for other industries. Easy memory tricks. 1+1 rule, both labor court and tribunal equals 1 presiding officer. Judge ladder, high court, district judge, 3 years, judicial officer, 7 years, labor officer, 5 years. Legal trio, judge, Labor Commissioner, Indian Legal Service. Finance Act 2017 link. Tribunals also handles EPF cases, central governed. Gazette, go officially. Every setup must be notified officially. Daily revision tips. Day 1, read both sections aloud once plus write keywords only. Day 2, recall qualifications. Make acronym JDJLCLS, Judge, District Judge, Labor Commissioner, Legal Service. Day 3, quiz yourself. Who appoints? How many members? Weekly trick. Teach someone else. It strengthens memory. Visualize. Labor court equals smaller issues. Tribunal equals bigger plus EPF issues. Quick recap line. Labor courts equals second schedule issues. Industrial tribunals equals second plus third schedule EPF after 2017. Both equals 1 presiding officer with legal judicial experience, appointed by Gov via Official Gazette. Would you like me to make a super mnemonic story-based memory aid, like a funny short story to remember all qualifications and powers instantly? It's great for exam recall. Ultra Best One-Page Cheat Sheet, Sections 7A, 7B, 7C, and 7D, Industrial Disputes Act, 1947, State Amendments. Section 7A, Industrial Tribunals, Central State Amendments. Purpose: tribunal deals with industrial disputes referred by government. Composition: 1 presiding officer, appointed by appropriate government. Qualification: Central Act, must be or have been a judge of a high court. State Amendments, Karnataka, Act 6 of 1963, added Clause AA, presiding officer can be a district judge or ex-district judge. Karnataka Act 35 of 1963, modified Clause A, must have been district judge for at least 3 years. Kerala Act 28 of 1961, substituted Clause A, must be judicial officer not below rank of district judge or qualified to be high court judge. Orissa Act 6 of 1960, added Clause AA, must have been in Orissa Superior Judicial Service for at least 7 years. Memory trick. Karnataka 3 years, Orissa 7 years, Kerala equals high rank, high court link. Section 7B, National Industrial Tribunals, authority, constituted by central government through official gazette. Purpose, to adjudicate disputes of national importance or affecting industries in more than one state. Composition, only one person, presiding officer. Qualification, must be or have been a judge of a high court. Assessors, central gov may appoint two-person tribunal. Memory trick, national equals one judge plus two advisors plus central gov. Section 7C, disqualifications for presiding officers. No person can be appointed or continue if A, not an independent person, no bias or interest. B, has reached age 65 years. Memory trick, disqualify, no bias, not old, 65. Section 7D, qualifications, terms, and conditions. After Tribunals Reforms Act 2021. After Tribunals Reforms Act 2021, all matters about appointment, qualification, salary, term, resignation, removal, etc. governed by Chapter 2 of Tribunals Reforms Act 2021. Exception, presiding officers appointed before Finance Act 2017, Part 14 of Chapter 6, continue under old Industrial Disputes Act rules. Memory trick, post-2021 equals new rules under Tribunals Act. Pre-2017 equals old ID Act rules. Important years, 1947, Industrial Disputes Act. 1960, Orissa, 7 years judicial experience added. 1961, Kerala, district judge rank added. 1963, Karnataka, district judge clause, 3 years. 2017, Finance Act transition. 2021, Tribunals Reforms Act enforced. Quick revision tips. 1. Visual chain. 7A, who forms tribunal. 7B, national level tribunal. 7C, who can't be presiding officer. 7D, post-2021 service rules. 2 mnemonic, a big clever decision. A, 7A, B, 7B, 7D. Daily 2-min revision plan. Day 1, read all section names aloud, 7A to 7D. Day 2, recall which section talks about which tribunal. Day 3, revise state amendments, Karnataka, Kerala, Orissa. Day 4, recall disqualification, independent age 65. Day 5, revise 2021 and 2017 rule changes. Repeat weekly, 1-min oral recall test. Hash of memory anchors. Karnataka, 3 years district judge. Kerala, district judge rank, high court qualification. Orissa, 7 years superior judicial service. National tribunal, 1 judge plus 2 advisors. Disqualify, not independent, 65 years. 7D, 2021 reforms, Tribunals Reforms Act. One-line essence, open quote, industrial and national tribunals need senior judicial officers, fair, independent, under new 2021 tribunal rules with states refining qualification years. Close quote. Would you like me to make a visual memory map color-coded for this so you can remember since 7A, 7D plus amendments in under 2 minutes? Ultra best one-page cheat sheet, filling of vacancies and finality of orders, labor laws. Section 8, filling of vacancies, meaning if a post becomes vacant, not just temporarily, in labor court, tribunal, or national tribunal, it must be filled. Who fills vacancy? National tribunal, central government. Labor court, tribunal, board, court, appropriate government, state or center, depending on the case. Rule, new appointment must follow the same procedure as the original appointment under this act. Effect, once new person is appointed, proceedings continue from the same stage, not from the beginning. Purpose, to avoid delay and ensure smooth justice process. Example, if labor court judge retires mid-case, new judge is appointed, case resumes from where it stopped. Section 9. Finality of orders constituting boards, etc. 1. Finality of appointment orders. Appointment of any chairman, member, presiding officer by Govt cannot be challenged in court. Proceedings of any board or court cannot be questioned only because there is a vacancy or a defect in its constitution, like missing member, wrong appointment. Purpose, prevents unnecessary delay or invalidation of justice due to small technical errors. 2. Validity of settlements. Even if time expired, settlement made after expiry of the prescribed time limit under Section 12(6) or 13(5) is still valid. Example, conciliation talks continued after official deadline, agreement made later, still legal. 3. Absence of members during settlement. Settlement signed by chairman plus all members of the board remains valid, even if any member, including chairman, was absent for some meetings. Purpose, avoid invalidating settlement for small absences. Keywords to remember: vacancy, appointment, continuation, central govt, appropriate govt, finality, validity, no challenge, settlement, absence. Tricks to remember: 1. Vacancy, govt fills, case continues. 2. No challenge, no delay. 3. Expired time, expired validity. 4. Absent member, invalid settlement. Daily revision tricks: 1 min flash drill, recite 8 equals vacancy filling, 9 equals finality and validity. Mnemonic: VFAV, vacancy, finality, appointment, validity. Quick recall practice: ask yourself daily, who fills a national tribunal vacancy? Central govt: what if a member was absent? Still valid. Can appointment be challenged? No. Exam hack: focus on who appoints whom, plus cannot be questioned lines. 3 golden phrases to quote in answers. 1. In accordance with the provisions of this act. 2. Proceeding may be continued from the stage at which vacancy is filled. 3. Shall not be called in question in any manner. One-line essence: vacancies are promptly filled by govt, proceedings continue smoothly, and appointments or settlements cannot be challenged for technical defects or delay. Ultra Best One-Page Cheat Sheet, Section 9A and 9B, Notice of Change, for instant exam revision, crisp, complete, and memory smart. Section 9A, Notice of Change. Core idea: employer can't change service conditions listed in fourth schedule without proper notice to affected workmen. Key points: mandatory notice. Before changing any service condition, employer must give notice in prescribed form to the affected workmen. Waiting period: change can be made only after 21 days from giving the notice. Matters covered: fourth schedule examples, wages and allowances, hours of work, rest intervals, leave rules, shift timings, holidays, promotions, transfers, retrenchment, etc. No notice needed when 1. Change is made as per a settlement or award, mutual or tribunal decision. 2. Workmen come under government service rule and supplementary rules, FSR. Civil services, classification rules, civil services, temporary service rules, revised leave rules, civil service regulations, civilians in defense services, CCNA rules, Indian Railway Establishment Code, any other govt notified service rule. Purpose: protects workmen from sudden, unfair changes, promotes industrial peace and consultation, ensures transparency and time buffer, 21 days for discussion objection. B. Power of exempt core idea. Government can exempt certain industries' workmen if it feels strict application will harm public interest. Key points: who, appropriate government, central or state. When, if applying Section 9A may affect employers too badly or cause serious industry repercussions, e.g. strikes, shutdowns, loss to public. How, through notification in the official gazette. Effect: Section 9A may not apply at all or apply with certain conditions, partially relaxed. Example: in a crisis, like pandemic or war, govt may exempt hospitals or essential industries from 21-day notice rule, so changes, like shifts or duty hours, can be made immediately. Memory anchors, quick recall tricks. 9AA for advance notice, 21 days notice before change. 9B for bypass by government. Govt can exempt bypass rule. Fourth schedule F for factory rules, covers service condition details. 21 days wait, 3 weeks gate. You must wait 3 weeks before change. Pasture exam smart summary. 9A equals notice before change. 21 days equals mandatory waiting period. Exceptions equals settlement, govt service rules. 9B, govt exemption power. Objective equals protect workmen to ensure fair industrial relations. Daily revision tricks. 1 minute flash drill. Repeat keywords. Notice, 21 days, fourth schedule, settlement, Guft rules, exemption, gazette. Create mnemonic, N21 Esser Gov, notice 21 days, settlement, rules, exemption, GovTuft. Micronote on sticky, 9A equals notice, 9B's Govt exemption, and stick near study table. Revision routine, day 1, read full section in plain meaning. Day 2, recall from memory. Day 3, explain to yourself in 2 lines. In essence, section 9A equals no change in workman conditions without notice, 21 days gap. Section 9B, Govt may relax or cancel this rule for public interest. Would you like me to make an ultra-compact mnemonic map, visual memory diagram, next, for quick visual recall of 9A to 99B? World's Ultra Best One-Page Cheat Sheet, Chapter 2B, Section 9C, Grievance Redressal Machinery, plus Rajasthan Amendments. All keywords, numbers, and facts in one crisp page. Perfect for last-minute revision. Section 9C, Grievance Redressal Machinery. Applies to industrial establishments with 20-plus workmen. Must set up one or more grievance redressal committees, GRCs, for individual grievances, not collective disputes. Equal representation, same number from employer and workmen. Chairperson, alternates every year, rotation between employer side and workman side. Max members, 6 only. Women inclusion, 1 woman if 2 members. If more, increase proportionately, e.g. 42 women, 63 women. Timeline, GRC must complete case within 30 days of written complaint. Appeal, worker unhappy, appeal to employer. Employer must decide within 1 month and send written decision to worker. Right preserved, worker can still raise industrial dispute even after GRC decision. Exception, if workplace already has established grievance mechanism. 9C not compulsory. Purpose and essence, quick and fair internal system for individual disputes, reduces strikes, saves time, promotes trust. Workflow, easy flow. Complaint, written, GRC hearing, 30 days. Decision, appeal, 1 month, employer's reply. If unhappy, industrial dispute option open. Numbers to remember, 20, minimum workers for GRC, 6, maximum members, 30 days, GRC decision time, 1 month, employer appeal disposal, 1 woman must if 2 members, 1 year rotation, chairperson alternates annually. Keywords, GRC equal grievance redressal committee, equal representation, rotation of chair, fair and quick remedy, individual grievance, 30 days disposal, appeal within 1 month, women representation, not replacing industrial dispute right. Rajasthan Amendments, only for Rajasthan. Chapter 2B, renamed Chapter 2C. Section 9D, 3 continuous months, changed to 3 months in last 6 months. Section 9E, union registration valid 2 years, continues unless canceled, replaced. Section 9F, cancellation allowed after 2 years of registration. Section 9G, new union only after 2 years, same 3 and 6 months rule for membership. Section 9D, 15% replaced by 30% threshold. Section 9C renamed as 9CC, technical renumbering. Why GRC matters. Exam hint line. Ensures internal, time-bound, equal, and gender-inclusive mechanism for resolving individual grievances without removing legal rights under the Industrial Disputes Act. Tricks and memory anchors. 2631. 20 workers, 6 max members, 30 days GRC, 1 month appeal. Rotate chair, represent fair, resolve fast. Include women, fair voice always. GRC equals quick court at workplace. Rajasthan equals 2 years valid plus 3 and 6 months rule plus 30% threshold. Daily revision trick, 2-minute method. Say aloud, 20 GRC, 30 days, decision, 6 max equal sides, 1 month appeal. Recall one example, like unpaid overtime. Whisper keyword mantra, rotate chair, equals share, resolve fair. Revise Rajasthan equals 2 years plus 3 and 6 plus 30%. Exam gold lines, write as one-liners. GRC mandatory for 20-plus workers, section 9C. Equal employer workman members, rotate chair yearly. Finish grievance in 30 days. Appeal within 1 month. Workers' right to industrial dispute unaffected. Rajasthan, 2-year union validity, flexible 3 and 6 rule, 15%, 30%. Essence in one sentence. Section 9C builds a fair, fast, gender-inclusive, and balanced committee in every 20-plus worker industry to handle individual grievances within 30 days, keeping the workers' full legal rights safe. Would you like me to make the next one-page cheat sheet for Section 9D, Rajasthan Representative Unions, next in the same crisp ultra style? Absolutely. Here's the world's ultra-compact one for Section 10, reference of short, precise, memory-friendly with keywords, bullets, examples, and revision tricks. Section 10, reference of industrial disputes, ultra-compact notes. 1. Who acts? Appropriate government, state govt, state dispute, central govt, multi-state national. Can act when dispute exists or is apprehended, likely to happen. 2. How govt acts? Must issue written order. Can refer dispute to board, promote settlement, no legal power, court, inquiry on facts, labor court, legal adjudication, second schedule issues, tribunal, legal adjudication, second and third schedule, 100 workers, national tribunal, national importance, multi-state impact. 3. Special rules, public utility dispute, must refer after Section 22 notice unless frivolous, vexatious. Such 100 workers in third schedule dispute can go to labor court instead of tribunal. Central govt can use state labor court tribunal if needed. 4. Party request. Parties, workers, and employers can apply for reference. Govt checks majority representation, must refer. 5. Time limits. 2A. Disputes, max 3 months. Extensions allowed if presiding officer agrees. Civil court stay, excluded from period. Expiry, case does not lapse. 6. Strikes, lockouts. Govt can prohibit strike lockout after reference. 7. Points of dispute. Tribunal, labor court, national tribunal must confine adjudication to points specified plus incidental matters. 8. Including other establishments. Govt can add other affected establishments anytime before award submission. 9. National tribunal priority. If referred, no labor court tribunal jurisdiction. Pending state tribunal proceedings, quashed. 10. References in law, central versus state. Dispute under national tribunal. Certain sections, central govt acts as appropriate govt. 11. Death of party. Case continues, award submitted. 12. Keywords, memory anchors. Board equals settlement. Court equals inquiry. Labor court equals second schedule, wages, hours. Tribunals, second, third schedule, bigger disputes. National tribunal equals national importance, multi-state, plate 100 workers, labor court, public utility, section 22 notice. Time limit 3 months, individual. Strikes stop, points only, other establishments included. Proceedings continue if death 13. Example memory trick. BCLTNN, Board, Court, Labor Court, Tribunal, National Tribunal, Notice, Section 22. 3S plus P, 3 months, stay excluded, submit award, prohibit strike. 14. Quick story for revision. Factory dispute arises. Govt refers labor court wage issue. Strike prohibited. Court decides nearby factories added. Worker dies. Case continues. Award submitted. Nash, daily revision trick. 30-sec memory anchors. Morning. Recite BCLTN plus 3S plus P. Afternoon, recall who decides what. Board, court, labor court, tribunal, national tribunal. Evening, visualize story example. Factory dispute, step by step. Before exam, recall keywords only. Board, court, labor court, tribunal, national tribunal, section 22, 3 months, strike stop. If you want, I can make an even faster one-line ultra memory cheat for section 10 that you can revise in 10 seconds before exams. Literally, all key points in one glance. Do you want me to do that?